Under current law, when an individual passes away, their assets are placed into an estate. The management and distribution of this estate typically require a legal process. If the deceased left a will, an executor must apply for probate to manage the estate according to the will's directives. If no will exists, a person must apply for letters of administration to manage and distribute the estate's assets. Attorney General Anil Nandlall has explained that previously only legal spouses had the authority to apply for letters of administration, but recent amendments to the Deceased Persons Estate Administration Act now extend this right to common law spouses, acknowledging the role they play in the lives of the deceased. Additionally, if no spouse is available, a child or a sibling can apply for letters of administration.
When you die, your property goes to your estate. Nobody can transfer it, nobody can sell it, nobody can mortgage it, nobody can give it away unless you go to the court and that person applies for letters of administration. Of course, if the deceased person leaves a will, then that person will have to apply for probate of the will. And the person I'm talking about must be a qualified person.
One notable change in the bill addresses the financial burden associated with estate administration. Historically, small estates often left limited funds that were insufficient to cover the cost of probate or administration. For example, estates with 1,000 or less were subject to the same administrative processes as larger estates, which could be expensive. To address this issue, 2 years ago, legislation was amended to increase the threshold to $750,000. Nandlall emphasized that this update is intended to alleviate financial strains on families during difficult times.
And to make the application for the probate or to make the application for the letters of administration is sometimes more expensive than the money that is in the bank or the money that the deceased may be entitled to, wherever it is lodged. So the law about 40 years ago had put that if it is $1,000, the person who is entitled to the probate or the person who is entitled to the letters of administration can go and access that $1,000. Now, that may have been a good sum, a hefty sum of money 40 years ago. But clearly, $1,000 can do nothing now.
The Deceased Persons Estate Administration Amendment Bill 2024 aims to streamline estate management, reduce administrative costs, and provide equitable access to funds for beneficiaries.